Welcome to This Explainer. Today, we're unpacking a massive 1935 tax and family law case that literally redefined the boundaries of a taxable family unit. We're talking about the landmark Commissioner of Income Tax versus G. Lakshminarayan. Now, if you're a law or commerce student, you already know that pinning down the exact legal definition of a household is absolutely crucial, right? Well, today, we're looking at a scenario where a family faced a tragic loss, and that structural change sparked an all-out war over taxation. Let's get into it. To keep things crystal clear for your notes, we're structuring this explainer using the classic IRAC method. We'll quickly hit the facts of the case, the core legal issue, the relevant rules and statutes, the arguments from both sides, the court's reasoning, and finally, the ultimate judgment. Starting right off with Section 1, the facts of the case and a major shift in the family unit. Okay, so every great case starts with the facts on the ground. Picture a very traditional family setup governed by the Mitaksara School of Law. Step 1, we've got a classic Hindu undivided family, an HUF, made up of a father, a mother, and their son, G. Lakshminarayan. But then, tragically in Step 2, the father passes away. This leaves the son as the sole surviving male coparsoner. So by Step 3, the family unit has shrunk down to just the son and his mother. And then, Step 4 happens. Tax season rolls around and boom, this structural shift triggers a huge legal dispute. This disagreement at tax time basically presented two totally conflicting views on the son's legal status. On one hand, you have the son, the SSE, arguing that income from their ancestral property should still be taxed at the HUF rate. But on the other side, the income tax department, representing the revenue, vehemently disagreed. Because there was only one male member left, they insisted the jointness of the family was totally dissolved, and they pushed to tax him strictly as an individual. And remember, back then, being taxed as an individual rather than an HUF usually meant a much higher tax burden. Which brings us to Section 2, the core legal issue, and how we actually define an HUF. The whole case essentially rests on this one crucial question. Can a single male member living alongside female members like his mother actually constitute a Hindu undivided family under the Income Tax Act? Basically, does the lack of a second male just instantly wipe out the legal existence of the family unit for tax purposes? Moving to Section 3, Rules and Statutes, focusing on the Mitaksara School of Law. To figure this out, the court couldn't just guess. They had to look at the strict definitions from centuries-old legal traditions alongside the 1922 Income Tax Act. First up, let's pin down the definition of a coparcenary. Think of this as a very narrow, exclusive club. It strictly includes only the males within a family who own ancestral property by birth. It's entirely gender-based, and it's basically a numbers game. But contrast that with the joint Hindu family, which is a much, much broader concept. It includes those male coparceners, sure, but it also explicitly embraces wives, widows, and unmarried daughters. So the law recognizes a massive distinction here between the narrow property-owning group of males and the wider, more inclusive family unit. Keep that in mind. All right, Section 4, Arguments of the Parties. Revenue versus assessee. Both sides really dug in on whether that narrow or broad definition should apply to the tax code. The revenue took a super strict numerical approach. They basically said, look, a family requires a plurality of persons who can demand partition. And since a mother couldn't demand partition against her son under the law at that time, and the son was the only male left, they argued he was the absolute owner. Therefore, no undivided interest left. Case closed, right? Well, not quite. G. Lakshminarayan came back with a brilliant counter-argument. He said, yes, my father's death changed the management of the property, but it absolutely did not change the character of our family. He pointed to the potential for future children and, crucially, his mother's ongoing, legally binding right to be maintained by that estate. Let's look at Section 5, Reasoning of the Court. Honestly, this part is a masterclass in legal interpretation. The Bombay High Court's response was incredible. They dissected the nuances of the law, and their entire logic rested on one foundational distinction. Make sure you highlight this. While every coparcenary is an HUF, not every HUF is a coparcenary. That single sentence perfectly resolves the tension. The court basically told the tax department, hey, you're confusing a narrow property concept with a much broader family concept. The bench then systematically dismantled the revenue's argument using three solid pillars: the mother's rights, statutory language, and potentiality. Let's break down exactly how each of these pillars crush the tax department's strict numerical logic. First, the judges pointed out that under Hindu law, the mother holds an inherent, undeniable right to maintenance from the estate. Plus, she actually has a right to a share in the property if a partition ever takes place between sons in the future. Because she holds these legally binding rights against the ancestral estate, her mere presence means the legal family status is alive and well. The family absolutely had not dissolved. Second, let's look at the statutory language. The 1922 Income Tax Act specifically uses the phrase Hindu undivided family. It does not say Hindu undivided coparcenary. The judges hit the nail on the head here, noting that the legislature chose this broader term on purpose. But using the word family, lawmakers clearly intended to capture the actual social reality of the Indian household, which obviously includes mothers, widows, and daughters, instead of just focusing on strict property ownership rules. And finally, the third pillar, potentiality. The court noted that the property in the son's hands was ancestral. He didn't just earn it himself. So the fact that he was the sole surviving male didn't magically strip the property of its joint character. Why? Because if the son were to marry and have a child the very next day, that child would instantly become a new copartner by birth. This potential, layered with the mother's existing rights, proved the family was completely intact.
Which brings us to Section 6, the final judgment, and how this set a massive precedent.
After weighing all these definitions and rules, the Bombay High Court ruled decisively in favor of G. Lakshminarayan. They held that the income from the ancestral property absolutely had to be assessed as the income of a Hindu undivided family. This was a massive win, protecting the assessee from being wrongfully taxed as an absolute individual owner. So what's the big takeaway from all this? The legacy of this case is huge. It established the landmark principle that a single male member, along with the widows of deceased coparceners, can absolutely constitute an HUF. It stopped the tax department dead in its tracks, preventing them from artificially splitting legally sound families just because the number of males temporarily dropped to 1.